in Article 133 of the Constitution and Rule 54 of this court's rules. We accordingly pray that this application be dismissed as an abuse of court process. And even though we are all aware that in constitutional matters like this, no costs are awarded, I think this is a proper occasion.
Is this a constitutional matter?
Yes, it is, more or less. It's a special jurisdiction under the Constitution, yes. Okay. So, and if it isn't, more so, why costs should be awarded.
Mr. Kotuapa, I'm interested in why you permitted Mr. Kweku Asrifi to swear, to depose to the affidavit in opposition on behalf of the second respondent when he is not on record as the attorney for the second respondent. What we have on record is that Mr. Kweku Asrifi is one of the counsel announced in this case. Is there any justification why?
Yes, my lords. The attorney has powers to testify.
There are factual matters that has been deposed to. We have been told that one Peter McMenu is the attorney for the second respondent.
Oh, relax.
Well, from this practice where lawyers who are engaged by parties take it upon themselves to depose to affidavit when the parties are there. Can we justify it?
My lords, as I've indicated, lawyers take instructions from their client. Our client is the second respondent. Mr. McMenu was given a power of attorney to go into the witness box if necessary to testify. So that is the distinction.
And he has given power of attorney to...
No. My lord, you seem not to understand me. The attorney, power of attorney, was simply for him to go into the witness box in relation to his witness statement.
So when an affidavit will have to be sworn to, who is it lawyers who swear affidavits on behalf of clients?
Well, my lords, in circumstances like this, I believe that it is in order and permissible for lawyers to swear to affidavits.
Very well.
Yes.
My lords, respectfully, if with your leave, I may just make two quick points, because reference was made by my learned friend to the first words of Section 26, except as otherwise provided by law. And my learned friend made that reference in order to suggest that perhaps there is some other law that enables 36 to be put out of court. Well, my lords, our ground is that your lordship's decision, respectfully, was per incuriam of Section 26. It's not as if your lordships adverted to Section 26 and then said that because of some other law, we are not going to apply. That's not what happened. Your lordship didn't advert to it. Now, and it's quite clear in their opposition. It's quite clear that that's what happened, because they then tried to use your lordship's ruling on the 16th of February. They tried to use that.
My lords, we have not tried to use that. So my counsel should not refer in responding to my submissions that they have used it. We have not made any such reference in our affidavit.
There's such a unity of purpose.
There isn't. We are different parties.
And my lord, my only other point by way of response is that counsel for the first respondent asked, what reliance did we place on the depositions that were made. Evidently, we relied on that to close our case as we did. Because, my lords,
is it a point of law?
I'm sorry.
Is it a point of law?
I'm sorry.
Is it a point of law?
Is it a point of law?
Yeah, what you want to respond
well,
to?
My lords, the issue was really whether we had relied on it. That's a point of law, whether they had been relying, because they're saying that
no facts.
That's fact.
It's not.
I think, my lords, so my lords, on what evidence are your lordships going to? No, on what evidence are your lordships?
Order.
Respectfully, then the question is, on what evidence are your lordships going to determine that matter of fact? My lord, respectfully, this, I think, is an appropriate situation where it's really a mixed question. It's a mixed law, in fact, because he is saying that legally, the reliance on the deposition is part of what kicks in Section 26. And my point is that, yes, in reliance on that deposition, we close our case. I mean, we made that evidently clear in this court, because
so you've made this point. Their view is that you did not rely on it because you pursued those applications. Your view is that you relied on it, and it's on that basis that you closed the case. So we have heard both of you.
It is not just my view, because the question whether we relied on it, it really lies within our courts, much more than their speculation. Because nobody can speculate in terms of the conduct of our case. The conduct of our case, as we had it, relied on, because when you come to court, you rely on what comes to you from the other side as well. So, my lords, we clearly relied on that conduct. And our main submission on that Section 26 is that your lordships did not advert to that, much less try to
realize
qualify.
that you did not, in your submission on that day, you never referred to Section 26. On your submission, during your submission.
My lord, on that day, your lordship asked me, is it an estoppel argument?
No,
and I said, yes.
No, that was the answer. You did not refer to as Section 26. Section 26 have come into play in these proceedings during the last arguments. That was when you relied on, because I've looked at the proceedings of the 9th February.
Yes, my lord, I did not refer to Section 26 on that occasion because, my lords, the question about estoppel, your lordship asked me, and I said yes, it was estoppel. I did not refer to Section 26, but that's a matter of...
The question about estoppel was asked during the last...
your lordship asked me the question about estoppel during the transcript.
That is what caused you to write to us, that you needed to give further submissions.
No, my lords, respectfully, my lords, no, that is not, respectfully, that is not the case. The transcripts are very clear, respectfully. My lords,
I have a question.
Yes.
I have a question. My question is, these affidavits, were they not sworn to before the trial, before the hearing? They were sworn to during the interlocutory application.
My lords, affidavits sworn to during...
No, I'm just asking a question. Were they not sworn to before you put your witnesses in for hearing?
Yes, they were.
Thank you.
And my lords, that has no significance for the reliance. It has no significance for the reliance that we placed on it in the conduct of our case. Because your lordships will...
I'm satisfied with your answer.
Well, you can't be satisfied with your answer.
Order.
Yes.
Order, please.
My Lord, you can't be satisfied when I have not completed my answer.
Order in court, please.
I've not completed my answer, and your Lordship says I'm satisfied with your answer. You're cutting me short in giving an answer that will address what underlies your question, because what underlies your, if my lady can allow me,
Just a minute. Respectfully, Mr. Chikata, these are matters of fact. The date on which the affidavits were filed, the date on which the trial was conducted, these are matters of fact. So I could even come to that, I could do that evaluation without asking you a question. I chose to ask you the question so that you could avert your mind and confirm. That is all.
yes, but
So in answering my question,
so may I complete my answer?
very well, Mr.
Because, my Lord, when affidavits are sworn to in interlocutory proceedings, in the course of a trial, it is open, for instance, to put the matters that were deposed to in an affidavit in interlocutory proceeding to the witness when he enters the witness box, and to put before them, didn't you say this on oath in an affidavit before this court? This is a matter that is quite basic in the practice that I'm familiar with, that when you have an affidavit sworn on oath in interlocutory proceedings, and a witness comes into the witness box to testify, that affidavit can always be put to them in terms of the veracity of the things that they stated. So you can't say that just because this was done in the course of interlocutory proceedings that were before the trial itself, they have no bearing on the conduct of our case. Because my Lord will recall, my lady will recall, that this whole matter of crossing that bridge when we get there was in terms of whether cross-examination would provide an opportunity for those matters to be addressed. And your lordships, one or two of your ladyships, put across the perspective that shouldn't we be waiting until cross-examination before we address those matters? And indeed, that is precisely what we did, because your lordships ruled against us, so we had to wait for the cross-examination to take place. And we waited on the basis of sworn affidavits by the chairperson of the first respondent.
Please, the court will rise to consider his ruling.
All right.
Pusu Nalung in Bimbila or in Sekendi? Were you born? I see in your record Sekendi. Were you born in the Pusua in the Bimbila constituency? I know one Father Abdullahi who was serving in the police service, but I see in your record Sekendi. Which one should we rely on?
Thank you, Mr. Chairman. I was born in Sekendi, but I'm a native of Pusua in the Bimbila constituency.
But not born in Pusua?
No, please.
Okay, but you know when I mentioned the name Uncle Abdullah, it rings a bell in your head. You don't need to respond.
He was my father.
Okay, so it means that you should know that I have information. That's why I say that I'm asking on this particular matter. Now, again, your ministry's budget. Did you always satisfy minimum procurement requirement as minister?
Yes, Mr. Chairman.
Now, Chairman, I'm about ending. In the run-up to the election, we saw parliamentary candidates commissioning projects, like takeoff of projects. Yet there were members of parliament on this side, I should think even some from the other side, who didn't have that benefit. But you could find in some constituency, a parliamentary candidate come and cut a sword and refer it as a project under your ministry. The Honorable Ayalga is raising his hand. I could also raise my hand. The Honorable Ayalga is raising his hand. You didn't find that discriminatory?
Mr. Chairman, it never came to my notice. I'm not aware of that.
So if you do find out that development authorities gave out some projects to MPP parliamentary candidates, is that right?
So, Mr. Chairman, it tells you that I wasn't interfering in their work because they were doing
So there were those doing it. There were those giving out the contracts to parliamentary candidates.
I didn't know what was happening.
You didn't know?
Yes, please.
They didn't write to you?
No, please.
So if I bring a letter with lists of candidates, you stand strongly that you didn't know about it?
Yes, Mr.
But we need to improve our governance. I mean, that could be done for any member of parliament. But a parliamentary candidate, we question in what capacity were you doing that? I note that you have apologized for those excesses of shooting. That is not honorable, that is not ministerial, and particularly so that you are a woman. You should not be associated with those extra engagement of excitement with a gun. Chairman, on that note, I can only wish the nominee well, but will request for that additional information. I thank you, Chair.
Honorable Howard Crimson.
Want your petition back?
Around our constituencies, many of us, projects, one specific project started in the youth, have not completed. Small town water project or mechanized boreholes. Borehole sunk, overhead tank raised, tank on it, but to date, no mechanized, no water flowing through them. How did it so happen?
Thank you, Mr. Chairman. Mr. Chairman, the contractors are paid based on the work done. So maybe they might have raised the certificate and then waiting for their payment. And the water system is supposed to be installed with solar panels. So some of them are also trying to get the solar panels to install them for the water usage.
So when should the people of Bibomem in my municipality expect that water will flow through their...
Very soon, Mr. Chairman.
Very well. There were petitions, but all of them There were about matters on which you have answered questions already. So I think that violent tendencies, 80,000 to 800,000. You've answered them. Both of them are the same thing. So one from Governance Watch Alliance, one. The other from Care for Free and Fair Elections Ghana. Around elections, always some groups emerge, and one such group brought the petition. But you have answered questions contained in their petition already. So we thank you for attending upon the committee. We thank you for attending upon the House to answer.
Thank you, Mr. Chairman. I'm so
You're
grateful.
discharged. It's now that you can thank us. We are discharging you now. You hear from us. Thanks.
Thank you, Mr. Chairman.
Honourable members, we did 2 hours, a little over 2 hours. Let's stretch our legs. So we'll resume at 2 o'clock. Then we'll begin the consideration of the Honourable Member, Honourable Courtroom, at 2 o'clock.
any evidence. And it is in respect of that ruling that the petitioner has applied for a review. So this review application is in relation to the respondents closing their case. That is what it is.
All right. What is evidence by affidavit? One of the justices asked a very important question, or a question, as to when the respondent, for that matter, the first respondent, filed those affidavits. And so I just want to know what evidence by affidavit means, and what are the consequences depending on when you file those affidavits.
I can't purport to know or understand why the Justice of the Supreme Court asked that particular question, because we don't want to be prejudicial or anything of that sort. But simply put, an affidavit, and we've seen numerous examples of affidavits in this particular suit, every motion must be supported by an affidavit. That's why you hear the lawyers, when they're moving the application, say they're moving in terms of the motion paper and they're supporting or accompanying affidavits. When you file an application, say you want, the party files an application wanting, or in this particular instance, objecting to the respondents closing their case. The party in question, that is the petitioner, has to depose to an affidavit to support that particular motion. So in the affidavit, he would identify himself and refer to the fact that his counsel will refer to all the processes that are before the court and state why he deems the application or the motion necessary. So in this particular instance, the affidavit set out the facts that indeed on this day the court had arguments and the court affirmed the right of the respondents to close their case. But he is advised by counsel and verily believes, saying to be true, that the court did not avert his minds to blah, 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 and things of that sort. And so that affidavit supports the motion. And then there will be that statement of case that will, the counsel would argue when called upon to move this particular application. So affidavit evidence or affidavits are just those statements that are verified. And for instance, it needs to have a truth verification, need to verify the truth of the statements in question. And that's why, if you remember, in the affidavit of, I believe, was it in the witness statement, or it was an affidavit of Mr. Rojo Metsonuno? I think it was a witness statement where he talked about, I think there was more than 16 paragraphs, but he talked about 1 to 16 are true to his knowledge. The counsel on the other side sought to suggest that, is that a suggestion that the other paragraphs in that particular document were not true? And you saw how that was resolved, that it was amended to a large extent. And so that basically is what it is. But I can't tell you why the justice asked that specific question, that when were the affidavits filed or anything of that sort. What I can say is that the Supreme Court in these proceedings has stated clearly that you can only consider something to be evidence when the person making that particular statement, for instance, is in the witness box. And so to the extent that a witness statement, for instance, has not been adopted as the evidence in chief of a particular party, it's not before the court as in, it is not evidence before the court that can be relied upon in the determination of an application or anything of that sort.
Right. Also some clarity on some of the terms that came up. What is a ratio decidendi, and how is that formed, or how is that formulated? How do we come about that?
So when we talk about the ratio, so when judges deliver their judgments, they deliver their judgments on the basis of the evidence, the facts, and everything, and they come to a particular conclusion. but in their holdings, when they are determining the issues, they would determine the issues on the basis of the law applicable or the legal principles applicable to the particular issues and arrive at a particular conclusion. So the ratio decidendi is the most important part, arguably, of the case. That gives you the rationale or the reasons why the court is deciding in a particular way. And that is quite distinct from the obiter dictum. Obiter is simply those statements that the judges make which do not go to the core of the issue at stake. It is not the reason why they are arriving at that conclusion, but they are saying it also in passing. So the ratio is what to look out for. So in citing a case before a court for the court to come to your aid or for the court to rule on your behalf on a particular issue or something of that sort, it is the ratio that is important. That is the part that is of critical importance. So you saw counsel for the petitioner making reference to the ratio of a particular decision that was given, I believe it was in the Madamu Dramani case or so, where he was talking about the fact that the court ordered the accused person to open his defense in the interest of justice, as the justice so demanded. And that was the ratio, according to counsel for the petitioner, of that particular case, not necessarily the other statements that were made. So the ratio is the basis and the rationale for the decision that has been actually given on a particular issue, quite distinct from the obiter dictum, which are the statements that may be made, but are not necessarily the reason why that particular decision was arrived at.
Right. So it does appear that both the petitioner and the respondent, in making a case for and against this review, are basically saying some of the things that they've said already, some of the arguments that they've made already. Can you help us understand exactly what the two parties have been saying relative to this particular review, as we saw not too long ago?
So, and that's why it gets confusing, because the two issues seem, or there are two basic things here. This ruling, like I've said earlier on, is in relation to, this application before the court, application for review, is in relation to the ruling of the 11th of February. That had to do with the fact that the respondents had closed their case. And if you remember, counsel for the petitioner argued that the respondents themselves had elected to adduce evidence, and so they could not turn around on the basis of the witness statement that they had filed. It suggested that they were going to call witnesses to adduce evidence in that regard. And so that is one aspect of the whole of what we have before us. Another aspect is that there's also a ruling that was given, I think, 2 days ago or so, that had to do with an application by the petitioner praying the court for the court to give it permission to reopen its case so as to subpoena the chairperson of the Electoral Commission to testify. So the common ground between these two seems to revolve around the chairperson of the Electoral Commission. That's why the arguments may get confusing and convoluted somewhat, because there's one common denominator. In one sense, the petitioner, in applying for review of this particular ruling of the 11th of February, is praying the court to essentially compel the parties, by the parties' own acts, the election, which the petitioner feels that the party elected to adduce evidence, the party, the respondents must adduce evidence, and the court did not consider certain things in coming to that conclusion that they came to, that the affirming the party's right, the respondents' right to close their case. And so that is what the petitioner is seeking to do in this particular review, to have the court reverse itself on that particular issue, or on that particular point where the respondents had closed their case. So simply put, in this application, the petitioner is seeking the court to reverse itself so that the respondents are made to adduce evidence in the form of calling the chairperson of the Electoral Commission to testify. Right. And it seems to be the same basis for the ruling of 2 days ago, which had to do with their application seeking to reopen their case to compel the EC chairperson to testify by way of a subpoena. Right. And so it seems as though it's the same points, but it's being argued on different grounds. Because in the first instance, the February 11th ruling had to do with the respondents closing their case themselves. But, and the petitioner is seeking to have them reopen and adduce evidence because they believe they elected by the filing of the witness statements. They have indicated clearly that they were going to adduce evidence. Right. But the second instance, which was what we saw 2 days ago, was the petitioner now asking to reopen their case so that they can now compel the EC chairperson to testify by way of subpoena. So I believe that is the distinguishing factor between these two situations, and that may be what may be confusing a little bit, but I think you can unpack it and appreciate it within that context. Sure.
So that motion by the petitioners to reopen their case and file a subpoena in itself, wasn't it in a form a review of the 11th February ruling of the Supreme Court? Didn't it have that characteristic of a review?
There are two different things altogether, because in the first instance, the February 11th one, as you have rightly pointed out, they were objecting to the respondents closing their case. But in the 16th, the ruling that was given in relation to their application to reopen their case, which was given 2 days ago also, they were seeking to reopen their case. So the fundamental distinction is that in one hand, on the 11th February one, it was to have the respondents themselves open their case and call their witness to testify so that the petitioner has an opportunity to cross-examine the respondent's witness, the first respondent's witness. But the other application which you referenced, the one that the ruling was given 2 days ago, it had to do with their application seeking to reopen their case. Because remember, they had closed their case, and the respondents then also closed their case. And they filed an application that they objected to the respondents closing their case. And the court ruled in favor of the respondents. Then they filed an application to now reopen their case. So before they even filed this review application, they filed an application to reopen their case that, in simple terms, if the court has affirmed the right of the respondents not to open their case to adduce evidence, we are now filing an application seeking the leave of the court. Let us open our case. Let us reopen our case so that we get the opportunity to call the witness by way of subpoena to testify in the matter. So there are two different things altogether. On one hand, the petitioner is seeking to have the court have the respondents open their case and essentially call evidence or adduce evidence. But in the other hand, the respondent, the petitioner, is seeking the court or sought the court's permission, leave to reopen its case so that they themselves, by way of subpoena, could pray the court to grant it to call that particular witness to testify essentially as their witness, albeit they would treat that person as an adverse witness. So there are two different things altogether, except that the underlying basis or the common denominator is the fact that the petitioner wants the chairperson of the Electoral Commission to testify. That is the similarity between the two applications. But we need to note that the petitioner, even though he gave notice of the fact that he may be applying for a review of the second ruling of 2 days ago, we haven't gotten to that point yet. As far as I'm concerned, they haven't filed the application for review of the court rejecting their application to reopen their case. What they're dealing with today is the review of the court's ruling affirming the respondent's right to close their case. So that is the difference.
Okay, so in case the court upholds this motion to review and the court changes its mind, will the respondent have an opportunity for a review again? The respondent, can they also call for a review?
I don't understand your question.
I'm saying that if the justices, the 9 justices, if they uphold the application to review the 11th February ruling, and then the result is that they change their mind, will the respondent also have an opportunity to apply for a review of that particular ruling again?
I mean, generally speaking, it's an application by one party, and that party has applied to have a certain thing done, which has not been granted, and they've applied for review, which they believe that should be granted. So not in relation to this case, but generally speaking, if applications of that nature, a review of parties were supposed to highlight on their written addresses, and the assumption is that the parties have filed their written addresses by yesterday. So the situation is quite fluid, and so it's extremely difficult to tell exactly what's going to happen unless we wait to see what actually happens once the court gives its ruling, and we'll be able to proceed from there. So it's extremely difficult to tell what's going to happen, especially knowing what happened the last time that we were at this point where the court had delivered its ruling, and almost simultaneously around the same time the court was delivering its ruling, an application for review was being filed. So it really is a fluid situation that we have to see how it evolves.
But with the stay of proceedings, I mean, Stinger was referring to this particular application that was heard. So the intent to file another application, that has not been done yet. So as of now, the stay of proceeding was in reference to this particular application that has been heard.
Hello?
Yes. I'm saying that no, can you hear me?
Yes.
That the stay the stay of proceedings was actually referring to the application, this particular application that was heard. So irrespective of whatever happens with the review application, what happens to the stay of proceeding as at now? That's what's happening.
So two scenarios.
Yes.
If an application of this sort is before a court, and the court decides, not necessarily this court, keeping it general because we can't go into the merits of this particular, but let's say a review application is before a court and an application for stay of proceedings also in relation to that review application is before the court because some other steps have been ordered, and the plaintiff or the party in question that has brought that application believes that taking any further step prior to their application being heard will prejudice the whole matter.
Yes.
If the application is heard and is the review application, for instance, is not upheld, what it means is that if that stay of proceedings, that application of stay of proceedings was in relation to that particular application for review of the decision, and the decision is given that dismisses the application, then the stay application becomes moot in my mind, because at that point there's nothing to stay anymore, and the directions of the court hold at that particular point. But if the court upholds the application for review of a particular matter that is before the courts and grants whatever the party that has asked for is requested, for instance, the party was asking, had brought an application to review the decision of a court to say not permitted to reopen its case, and the court on review now decides that they have reviewed their decision and they permit them to reopen their case, then the next steps that was going to happen will necessarily have been stayed, because what it will mean is that the court is saying that you can now reopen your case and take certain steps or you may reopen your case and apply to take certain steps. And it is after those steps have been taken that the subsequent directions may be, we could go to that point. Because if you are applying to reopen your case to adduce evidence and all those applications are granted, what it means is that you have to adduce new evidence or evidence in that particular matter, which should be considered in any case, in any written address that you may give, as well as in the judgment that the court may give. And so to go ahead still, it will not make sense. It will be, it would be counterintuitive to, on one sense, say we've granted an application, you can reopen your case and adduce evidence, but in another sense, we're saying that whilst you're doing that, we have to also go ahead and file written addresses. I believe that's my mind, though, and that's not in relation to this particular case. That's generally speaking. It may seem counterintuitive to suggest that, because once the court gives that order, that it's reversed itself, and now you can adduce evidence, it means we are not yet at the point where the case is winding to an end. At least the evidence that is going to be adduced has to be evaluated. If there's a need for cross-examination or re-examination, that will be done, and the court will ascertain the credibility of the witness and all that before it gets to the point where all that evidence that has been adduced, albeit belatedly, will now form part of the total evidence that is before the court, so that the parties can now effectively deal with their respective addresses, and then the court may hear or may adjourn for judgment. But it depends on what happens. And like I'm saying, there are two scenarios that may occur that may determine the course of proceedings. But we don't want to speculate as to what is going to happen exactly in these proceedings, because the fact is we simply do not know.
No. Okay. Well, we'll leave it here and wait for the justices to return. And after the ruling, whatever happens next, we'll get back to you. All right, so that's Dr. Kweku Agyemang-Budu, who is he's a lawyer, he's a law lecturer, and the head of Law Center's Gimba Faculty of Law. So, Maurice, we'll be waiting for the outcome.
The Supreme Court is on a short break. They'll return to deliver that ruling on the application to review a ruling they made on the 11th. And so we are still here. We have men on the ground at the Supreme Court, Abdul Hai Mumen, Edward Nyako, and Barbara Kuma, who have been reporting and bringing you details of this particular Supreme Court hearing there. So as and when we get a signal, we'll go to the Supreme Court.
So if they file another application to review the reopening of the case, they want to. So the petitioner said that the lawyer said that they are intending to file another application for a review of the 16th judgment of reopening the case.
Sure. I mean, as the Chief Justice said, they are available. So you bring your applications or motions, and then we are going to. But one thing I also wanted to get from Doc is how many times you can review a particular ruling. So let's say after they rule on this, can the petitioner say we want another review of that ruling? And how it is going to.
On that basis, we also file an application to go for a quick break. We'll be right back.
Sure.
A male of about 40 years of age in an African print enters into a broadcasting studio, sit and speak.
Hi, my name is Kwame Sefakai. In my line of work, I interact with so many people who might be HIV positive. Every day, I work and associate with them because it's the right thing to do. It could be you. You shouldn't reject someone because the person is HIV positive. It's against their human rights. Let's do more. Let's show we care. Let's accept people living with HIV. It could be me. It could be you.
This message is brought